Inakumbuka wewe ni mmoja. Oh.
All right, good afternoon, members. Thank you very much for making time for this session. Apologies, we are starting a couple of minutes late. We had to set up a number of issues. So welcome to the meeting this afternoon. As mentioned, this is a session organized by the Nairobi Branch of the Law Society of Kenya through the Land Registry Liaison Committee, where we want to discuss the memorandum that was signed the other day between the Law Society of Kenya, the Institution of Surveyors, Kenya Bankers Association, and the Ministry of Lands to unlock transactions relating to long-term leases. Without further ado, we'll start with some brief opening remarks from our chair, Ms. Helen Namisi. Then after that, we'll have a panel discussion consisting of some members, including members from the Ministry of Lands, members from the practitioners, some who are involved in the drafting and negotiation of the memorandum, and some who are seeing the memorandum the first time, as most of you. Then we'll open up the session for feedback and questions from the membership. At this point, allow me to invite our chair, Helen Namisi, to give some brief opening remarks. Thank you, Madam Chair.
Thank you very much, Rubin. Good afternoon, colleagues, and welcome to this webinar. As Rubin has said, there was an MOU that was signed about 2 weeks ago. And as a branch, we felt that this was important for us to have an opportunity to unpack this MOU so that we can all understand its implications and how we can move around long-term leases. And so this afternoon, we are very honored and delighted to be able to have practitioners from across the board, corporate, the ministry, as well as those in private practice, to give us some insight as to the MOU that was signed and how we can go around this. I would also like to take this opportunity to thank very much the team that put this together at very short notice. This is Ribin Ondwari and Irene Kiwol, and thank you very much, members. I hope we'll have an opportunity to interact, to discuss this. Feel free to ask questions. And for those who unfortunately are unable to log in, please tell your colleagues that we are streaming this live on Facebook. They can join us there. And similarly, it will be recorded and it will be shared on our YouTube page for those who will not be able to watch it today. And so they can always catch up on the discussions later. So I do not want to take any more time. I want to hand it back to Ribin to take us through the rest of the program. Thank you. Good afternoon.
All right. Thank you very much, Madam Chair, for the very brief opening remarks. Once again, thank you very much, members, for joining us this afternoon. So we'll have a panel of the following people. We'll have Irene Kiwol, who's a partner at Mushemi and Company Advocates, who's also the co-convener of this committee at the branch. We also have Mr. Adnan Khan, who's a partner at Anjarwala and Kana Advocates, LN Kenya. So Irene Kiwol will speak from the side of the practitioners who are part of the team that drafted the memorandum. She'll just highlight some key areas which are important. Adnan Khan will speak from the aspect of the practitioners who are just interacting with the memorandum the first time, like most of us. Then we'll also have Belinda Nganga from HF. She'll also speak from the side of now financiers and banks from their perspective. Then from the Ministry of Lands, we have Mr. Paul Ndungu, who deals with survey matters. He was part of the team. He'll assist us to understand the aspects where, as you can see from the memorandum, there's an aspect that will be moved to survey to be able to give the costing and everything in terms of georeferencing. Then we have Mr. Tom Abuta, who's a legal counsel at the ministry, who will also assist us to cover some aspects in respect to the legal aspects. And finally, we'll have Mr. David Nyandoro, who will enable us to also understand the practical aspects. So to begin, allow me to invite Irene Kiwol to commence on that panel, and we'll follow just that panel the way we've discussed. From Irene Kiwol, we'll have Adnan, Belinda, then Paul, Tom, and finally Mr. David Nyandoro. So Irene, without further ado, you may commence. Irene, are you online? Okay, seemingly Irene Kiwol may be having a challenge. It'd be good to start with someone perhaps who's part of the team. So Belinda, if you're... Belinda, are you able to unmute?
Hello, good afternoon, Ribin. Can you confirm if you can hear me?
Yes, I can hear you.
Okay, great. Thank you, Ribin. Even as we wait for Irene, I think I was hoping that she would make the remarks on the memo, but allow me to just speak to this. I was part of the team, and first, thank you to the Madam Chair, the members of the LSK, any senior counsel present, all protocols observed. Good afternoon. My name is Belinda Nganga. I head the legal team. I'm the General Manager Legal Services at HF Group, and I was part of the team representing particularly KBA and the interest of the financiers, but an advocate, and therefore I was able to wear both hats. I was both an advocate and also financial. So I have not engaged with Irene, but I would assume that what she would have done is to take us through the memo and perhaps do that high level. And then I will hand over to Mr. Adnan, and then we'll come back unless, Ribin, you have a different proposal. Okay.
No, Belinda, that's fine. We'll also just check in with Irene to see, to ensure that, see if she'll be able to speak up to you before we get to Adnan, who will be speaking from the practitioners who are just seeing the memorandum the first time.
Okay, great. Thank you. So just the memo was issued on the 2nd of August, and this was after about 3 to 4 months of engagement. And I think as a member of that team, I'd like to really appreciate the CS, Cabinet Secretary, Ministry of Lands, and the Permanent Secretary as well, who are greatly involved and steered us in these conversations, and all the members of the KBA, LSK, and also the ministry, who zealously attended meetings with me every week. And we are happy that this was, we have gotten to this level. So the main aim of this was to unlock transactions that have been stuck since January 2023. And those are transactions in respect to long-term leases, where the 2-year period provided under Section 54(5) of the Land Registration Act had passed, and this was the moratorium period for manual registration. And this period anticipated that within those 2 years, all properties that were the subject of long-term leases would have been georeferenced, and all subsequent transactions would be undertaken under the Sectional Properties Act, the regulations, and Section 13(2) of the Sectional Properties Act. However, the ministry being cognizant that one, the time had been lost because the regulations were only gazetted in November of 2021, and also there were challenges with the system. There had been time lost, and so a further extension of this moratorium period was given to allow for the manual registration of long-term leases. So that is by way of background how the nature for the reason why we have this memorandum. Someone asked me whether this is a practice note, and I think I would like Mr. Nyabuto to confirm on that, Mr. Tom to confirm on that, because I know that clarification requires to be had, and the force of law of this memorandum. Number two, I'll talk to the transitional measures that have been indicated in the memo. So on the top of page 2, you'll see the projects that are affected, the nature of the long-term leases that fall under the ambit of this memorandum. And the 1.3a are projects which had partially registered units or long-term leases. So we have a scenario of a project that maybe 200 units, 60 had been registered, there are about 140 not long-term leases not yet registered. Those ones were stuck. And we needed to find a way around registration of those transfers to the eventual buyers. And then number 2, 1.3b, transactions or dealings with previously registered long-term leases. I'm a proprietor of a long-term lease. I need to sell it. I need to charge it. I need to do one transaction or another, but it has been stuck because of the expiry of the moratorium period. So those are the two dispositions that were being approved or that are covered under this memorandum. So what transactions are excluded? One, if it's a project and no long-term lease had been registered, the committee looking at this was very clear that those ones fall outside the ambit, and those ones will require to just go by way of Sectional Properties Act. So those very, very specifically were excluded from this memo. And I'll handle the first one on new applications for registration of long-term leases. So the approval that was granted and that is covered under this memo is that for partially registered leases, the first step is that the property owner, the project or the developer, will require to first appoint a surveyor who will have a mandate to carry out the georeferencing. This surveyor shall have to go and confirm that that project does exist. So do a physical inspection to confirm the existence of the property and the building and the project. The ministry gave reasons for this specific ask, and those were understood and accepted by the committee. So first, the project owner will have to appoint a surveyor, and the project owner will then, on that basis, make an application for registration and give an undertaking that, one, they have appointed that surveyor, and two, they have appointed them to conduct the survey and complete it, the georeferencing and complete it within 6 months. So one of the annexures to that will be that letter of appointment of the surveyor. So the two templates were drafted by the committee, one being that undertaking, and that is in part A of the schedule, and two, the surveyor's letter of acknowledgement, that is part B of this memo. So I'm on now page 3. So upon receipt of the undertaking, the registrar shall confirm the existence of the project, shall also confirm that there had been long-term leases that had been registered against that property prior to this memo being issued, and will then go ahead and register those long-term leases that have been so submitted and we'll do this either manually or on the Arisasa platform if the project has been captured on the Arisasa platform. One of the things that was demonstrated to the members of the committee during the various engagements was that the Arisasa platform has been enhanced to allow for registration of long-term leases, and that module has been now availed. I think that is still a subject of conversation, and Ribin will speak a bit to that because we did test it, and I think it was still partly completed, and some commitments were given to have it ready. So as worded in the memo, if a project has been captured on the portal, it is required to be, the long-term leases registration are required to be undertaken on the platform. If not, then it shall be done manually. Madam Chair, you'll allow me to go to 2.2, and then we'll address any questions thereafter. This is on registration of transfers and dealings of our long-term leases that had already been registered. So this is an example we are talking about where I'm already a proprietor, a registered proprietor of a long-term lease, and I need to do a disposition. So the issue had been, for example, the development has 200 units. Who is going to incur the cost of that georeferencing? Because all the other 199, for example, users are not particularly in a need to have that transaction registered at that point. So the issue was transactions are stuck because one, perhaps the management company shall not incur the cost, or that one person cannot get all the other 199 to do the transaction and to meet the cost of the georeferencing. So there was a great inconvenience around that. So what was approved was that this georeferencing shall be done by the Director of Surveys, and the Director of Surveys shall be in a position to determine the costs for the georeferencing of all the units in the estate, and that cost shall be divided proportionately for each unit. That cost shall still be borne by each unit owner and shall be registered as a lien against that long-term lease until the point the proprietor of the long-term lease shall be carrying out any disposition, any transaction. So that unlocks that one unit being done, or whatever number of units require one transaction. And then at the point of the next disposition, it will be registered. That lien shall be lifted after the amount for the georeferencing has been paid for that specific unit. So the register of the long-term leases, and I'm on page 3 now, bullet C at the bottom. The register of the long-term leases will be updated to note the new title numbers for each long-term lease, and notices thereof will be sent to the registered proprietors. So I think I've just done a high-level discussion or overview of the memo. Ribin, I can hand over to you for further directions.
All right. Sorry, there was a bit of an echo then, but we're good now. Thank you very much, Belinda, for giving us an overview of that. We now have Irene. Irene, you can hear us now?
Yes, I can.
Fantastic. So I'm sorry, we had to throw Belinda under the bus to cover that part which you had to cover. But now that
apologies, Belinda.
Now that she's covered that, if you may just briefly cover some salient issues which practitioners need to understand before we then move to Adnan, who can then also just give a comment based from a practitioner who's then seeing the memorandum the first time. Then we move to the Ministry of Lands team.
Okay. I think one of the key issues that, because I've got a few questions on these issues of registration, I think what members need to understand with respect to the registration, especially of the first part of ongoing registration, is what we agreed with the ministry. If the parent title has been gazetted for conversion, members, you must initiate the application for conversion for the parent title. And in the event that the ministry has not converted within 14 days, the parent title, then you can apply for the manual registration of that particular property. And that way, then you will proceed now to do registration of your remaining subleases on the physical register, which is the manual register. One thing I think we are getting a back and forth is the issue of compliance. And what we had agreed among ourselves as the committee is that the manual space of registration is to impute that the registry ought to be having the register under the LRA to be compliant with Section 7. So that I think we need to be abreast to that. So what you will not need to proceed on the manual space is properties that have not been gazetted for conversion. Those ones are the ones which you will automatically proceed to make the application with the requisite attachments of the developer's undertaking and the surveyor's confirmation of appointment. That's what you will proceed on the manual space. I think I just need to make that clear. Reuben, I don't think I would have anything else to add. I think the rest, Belinda had done a good job on it.
All right. Thank you very much, Irene, for those quick highlights. So before we go to the Ministry of Lands team, we'll also have Adnan Khan, who's a practitioner. Adnan, being the first, having interacted with the memorandum now outside the team that was involved in the negotiation and the drafting of the memorandum, I don't know what issues have you picked so far in the memorandum, and what are the key maybe aspects you'd want to highlight, and or something which you think as practitioners would have concern of or need clarification that can be obtained to enable smooth implementation of the memorandum.
Thanks, Reuben. So, Reuben, does it probably make sense for me to just probably share the list of questions, queries, and concerns? And then I guess, depending on whoever is available, can probably answer it for the membership. So I guess I'll just start off with the fact that it's good to realize and appreciate, I think, the steps that the LSK and the ministry have taken to recognize the challenges that we've had with registration of transactions with long-term leases. Unfortunately, I've had a very protracted receding hairline, trying to explain to clients why we're not able to proceed with transactions. So this is probably a step in the right direction. So a couple of questions or queries relating to the memo. So first and foremost, it's good to realize that the memo recognizes that, one, we have long-term leases, and two, we have sectional titles. And both title documents require georeference plans. The first question I have is that, can we take it that the ministry has now confirmed that we can proceed with two forms of titles, that is the long-term lease and sectional titles? And as I ask this question, I don't necessarily mean leases that were registered pre-August 2023. What I mean is, can we proceed with long-term leases post-August 2023? Because pursuant to Section 54 of the Land Registration Act, long-term leases are still recognized as an instrument of passing title under law. The second question that I have is that the Sectional Properties Act and the regulations provide for an exemption from the application of the Sectional Properties Act. In fact, if you look at Regulation 22, there are three instances or classes of properties which are exempt. The first is where reversionary interest does not pass to the purchasers or owners of the units, so it remains with the developer. The second is mixed-use developments undertaken in phases. And the third one is developments of national strategic importance. And an example of where I've potentially seen that third one applied is those properties in the SEZ areas. Now, what's not clear under the regulations, or at least how the regulations have been drafted, is that exemption seems to only apply to long-term leases that had been registered when the regulations came into force, but they don't seem to exempt the same type of developments post the regulations, which doesn't seem to make sense, because the same logic for exempting those properties in the first place is the same logic that should continue to apply to those units for the Sectional Properties Act not to apply. On to the second question, which is, and I think Irene has partly touched onto this, is does the georeferencing apply to properties that have not yet been listed for conversion? And I guess this touches two jurisdictions. So first and foremost, in Nairobi, we know there are a whole bunch of properties which have not yet been listed for conversion. So is it really possible to undertake georeferencing for these properties? I understand that there are some properties that have been surveyed and are about to be listed in the Kenya Gazette for conversion, but there are a whole bunch of properties which are not going to be listed for conversion because the Department of Surveys is still waiting for guidance from the ministry, because some of these properties, say, are situated near the airport, some are situated and near public areas, or some have questionable titles. Now, what process do we have to get written confirmation or feedback from the ministry on how to deal with these titles? Because where you have properties which have been surveyed and are about to be gazetted, I think those are simpler, and we can give some bit of comfort to even buyers that, the titles that they're dealing with are genuine or do not have an issue. The big concern we now have is there's a number of properties out there which have not been gazetted for reasons which the government is not publicly disclosing because they're waiting for directions. And the feedback that I've received is from the Department of Surveys is that they will not allow the georeferencing for the units that will be built on these properties, especially the ones where they have question marks on. So how do we deal with that, and how do we manage that? One, and is it really possible to georeference properties which have been surveyed but not yet been listed for conversion? I suspect there will be potential delay, and we may need to push for manual registration on the current plans we're using, and perhaps having a transition to use to do georeferencing later. The other question that has also arisen is, will georeferencing be required for long-term leases for properties outside of Nairobi? So, the same questions that I've raised in Nairobi potentially will apply outside of Nairobi, but I'm not aware of whether the cadastral plans and the geo mapping has undertaken for the rest of Nairobi. So does this memo impact the long-term transactions on long-term leases for properties outside of Nairobi? And the fourth question that we have is, how is this approval to be applied for? Is it a letter to the Chief Lands Registrar together with the supporting documentation, which is the undertaking from the developer and the letter from the surveyor, or when we do lodge those documents, we just need to submit it together with those two documents? And how long will the Chief Lands Registrar take to approve the processing of those documents take? The subsequent question we have is, the memo refers to ongoing developments where the developer needs to give an undertaking to complete georeferencing within 6 months. So georeferencing does not need to have been completed by that date. Does this therefore mean that the Lands Registry will continue to register the long-term leases as the developer and the Department of Surveys process the georeference plans? If this is the case, then at what point do we incorporate the georeference plans into the long-term leases, and what process will that involve? Is it a deed of rectification? Is it a supplemental deed? Is it a master declaration that will be registered against the mother title? What does that process look like? And then there was a process in terms of referring to a lien being placed on the title or on the long-term lease if a transaction is being registered against the long-term lease. Do we know what the nature of that lien will be, what the cost will be, and how long that process will take to determine the cost? A number of members are concerned with this particular lien clause because initial communication from the government was actually that this georeferencing process was meant to be free. And all of a sudden, we're now referring to georeference plans and costs. So there's a concern in terms of how much are these costs, and are these costs going to be constant or consistent, or will they depend on the type of development? So will vacant land be different from an apartment, or a townhouse from an apartment? So I think we need to get more clarity on these points. And is the intention more on georeferencing as opposed to conversion? Because the reason why I ask this is, tied to the question on how will the georeference plans be incorporated, is the intention that they're then going to force everyone to convert their long-term leases to sectional title? And I think this a question or a concern was raised earlier. So let's say, for instance, in a block of apartments with 50 apartments, you have one owner who wants to undertake a transaction, but the other 49 members are not interested or do not have the incentive to push for the conversion yet. How do we have one owner who proceeds with conversion and becomes the sole member of a management corporation, while you have the other 49 who are not yet members of that corporation? How does it work? What does it look like? What kind of legal obligations are we imposing on the sole member? The other concern that has been raised, obviously, is, the 6-month timeline. We've been talking about January to August, which is 8 months. Do we have a sense of how many georeference plans the government has been able to prepare for sectional units or apartments or townhouses or plots? And do we have a sense of idea whether the government actually has the capacity to complete all this preparing of the plans and having them approved at the county government and the Ministry of Lands within the 6-month period? Or is this 6-month period simply preparing georeference plans and then the approval period will be later? And then the other question that is there is, can a unit be georeferenced on its own and the other units left aside? This is also particularly tied to the question around where you have one owner who really wants to try and fast track a transaction on their property and the others are not. So does the lien only apply once that proportionate cost has been paid and that lien will be lifted? Or will that lien only be lifted once all the other units in that development have paid all their respective costs? I think those were the number of questions we've been able to come up with based on discussions internally and some of our friends that we deal with on developments. But happy to hear the thoughts, and I believe there may be other questions from the members of the LSK as well. Thank you.
Thank you very much, Adnan, for your contribution and in terms of mostly the questions. So we've heard from the first round of practitioners. We just picked an involvement of the practitioners who are involved in the drafting. That's Irene and Belinda. And we have Adnan, who was not involved in drafting, but deals with a lot of developments. So we'll have now to hear from the Ministry of Lands team. Of course, they'll give us the initial overview of just the appreciation of the memorandum and what they expect from us, but since Adnan has already raised some questions, also it will be good if we can hear those questions. But once now we've heard from the three of them, we'll open up the session to hear the questions from the members who are online. So we'll begin with Mr. Ndungu, who deals with survey. I will just make his remarks and also address some of the questions that have been raised. Then after that, we'll have Mr. Tom Abuta, who's a legal counsel in the ministry. Then we'll close in terms of this first phase with Mr. David Nyandoro in terms of now dealing with the operational aspects in terms of the registration. So, Mr. Nduru, can you hear us?
Yes, I can hear you. And you?
Thank you.
All right. Good afternoon, consultants. My name is Paul Dungu. I'm an officer working with the survey department. I'm a surveyor, and we do sort of the point man as far as conversion at Survey of Kenya is concerned. And I know even dealt with quite a number of you. I'm encouraged to see the good turn up, show an indication of the great interest that members have on this memorandum. And we are happy that we have a way forward on how we can address the issues. Being appointed by the Survey of Kenya, many of you have come to ask me various questions for which I did not have answers. But now with this memorandum, at least we have a way forward on how we can address the issues, or at least we have an agreement on how we can address matters, and giving us confidence that the advice that we give, or rather the advice I give, is what is expected across the ministry. And what we do at Survey of Kenya, even when you go to land administration or land registration, at least there will be continuity of my work, and because you will not be working in silos. So from a survey perspective, probably not so much, because I thought the memorandum was fairly straightforward. But I would say that because you are talking about section properties or georeferencing of the same, of the properties, is that Section Properties Act definitely is more of a subsidiary of the Survey Act, the Mother Act for surveys, and so a lot has been borrowed from that act, and the Section Properties Act is just coming in to complement where there were gaps that it could not be able to address, but more so vertical developments, or even where we have town houses. And survey is necessary because we need to map what is in existence. Like I was saying, a year ago or maybe 2 years ago, we went out to do an analysis of the number of sub-leases that had been registered, mostly in Nairobi, and we expect them to be so many. But to our surprise, when we went out there, we found that actually some areas were not even developed. So that's why it's important survey to be carried out. And I think the emphasis here in the memorandum is that the surveyor must commit in writing, or even commit that indeed the building, the property you're talking about, it is already developed. And this is important so that when surveyor is carrying out the survey, he can make measurements and sort of swear that this is the kind of measurements that he has observed, he has measured out in the field. Remember, even the purchasers of the units will also be interested to know how much area they are buying, how big the units are in square meters, because it also it has an implication on the cost of that. So it's important that the survey be carried out, and surveyors will be keen on that to make sure that what they besides this, they are required to be provided so that the surveyor can also be sure that what was actually approved by the county government is what was put up. Lest we have a building plan that has been approved for 10 floors, but then the contractor goes ahead and duplicates the 10th floor and make another 3. Those are some of the things that surveyors will be keen on, so that it can bring true reflection to our offices of what is actually in the field. Measurements is also important, because even the valuation, where issue of land implies, and also land rates, then it also dependent, among other factors, on the sizes of these units. Though this is more off from the memorandum, but it's good to mention that when we talk of georeferencing of buildings, it's to what we call fixed standards, fixed service standards, such that where we have general boundaries, like more so in areas of Kiambu, I've seen so many of such jobs in surveys being submitted to the Director of Survey, and then the fixing of those boundaries must be done, and before now the survey itself, or rather the building can still be surveyed. The presenters who are before me have mentioned about those properties that are not being converted, and there was a working procedure on how this to be done, where we apply to the Chief Registrar, and then within 14 days he's supposed to respond or give way forward. But I would also like to mention here, out of human practice, our experience, that there are those parcels that have not been converted because a client or owner somewhere initiated a process of survey of subdivision, but along the way he abandoned that process, and by the time he was abandoning it, already at Survey of Kenya, that land might have been subdivided, and even the maps at Survey of Kenya indicate that it's not one parcel. When it comes to conversion, we convert the most current layer, the most current transaction, survey transaction on the property. So you find that the property that the person has brought to you has not been converted. He's still holding the mother title, but at Survey of Kenya, some transactions have happened. So it's important, and we are open for that, to guide, to advise, to consult and get to know why this conversion has not taken place. We have seen many, and we have advised many that in case you want it to happen, then you have to apply for cancellation of that previous survey transaction, so that now we can continue with the mother with the mother title. So it's better to bear that in mind. Then there's the issue of fully registered units, whereby the Director of Survey is supposed to carry out the survey, and after carrying out the survey, then I've gotten a new terminology of RIEN. I thought I'd call it a restriction, that the registrar put a sort of a restriction, indicate that this person going to continue or had to continue transacting, he needs to pay such a certain amount of money, and this money will be shared among the unit holders in a pro rata form, based on the unit factor of each of the unit. So this is something that a Director of Survey will carry out, will come up with. I think Bwana Dan has asked that question, and the Director of Survey will come up and give guidance of how much money or how the fees that is payable for those services. Generally, the services are charged as per the size of the property that is being carried out, and with a minimum, this is a minimum limit that beyond, rather anything beyond a certain level, then price starts changing For this, we are talking of very small units in meter square. Of course, that's why we give them in meter squared, because generally they are small compared to the usual acreages that we are used to of large parcels. So I foresee that the data of service office will provide even more or less a consistent cost per each unit. There was a question on georeferencing of properties outside Nairobi. These are because we have not yet digitized properties outside Nairobi. Outside Nairobi, you are still using DD plans, both and LIMs, but because there's a requirement of Sectional Properties Act and even Land Registration Act that we move from DD plan and go to cadastral plan. Whenever you wish to carry out a section of property, or even that one for long-term leases, then it has to be converted first, and you get an LIM for that. And this is the practice that we have adopted for those areas of Machakos, Kiambu. They have been quite common, and indeed, even in the old Act of 1987, that was still a requirement. So conversion is for all the whole country. The only difference is that have been done one, and the title is cancelled, then you will be ordering where will the other long-term leases be attached to, because the mother title is gone. So it is not practically possible to do that. And then remember, it's issue of the common properties, where we need to share that common property on a pro rata basis. So that may not be practical to carry out a single unit, as had been asked. I know there are so many questions that have been asked by Adan. I only wish that such question could have been floated to the respondents much earlier, so that we can also give a very conclusive answers of this. He has mentioned about those areas, because this one square falls on our docket, where we are not be able to convert because of some determination still need to be made. It's a bit challenging to come up with a conclusive answer how to deal with a property that is inside maybe say JKIA, where there is also another survey that was carried out. And from what we have been, from my preliminary investigation, is that the survey could have been carried out for purposes of registering long-term leases on land belonging to Kenya Airports Authority. But along the way, maybe somebody missed and registered them as independent titles. And now these need to be worked out in consultation with such an institution, so that you can come into agreement. Those which are said to be falling maybe in the forest rad again, probably such discussions need to be carried out, so that there can be an agreement whether such people should surrender such titles, and then they be given subleases by that institution if the KFS can give long-term leases on the areas that people are occupying. So some of these are high level; they need to be decided upon by higher authorities, and so this is what we have been also waiting for, even as we give our advices on how probably that should be carried out. So I feel the concern of members because I'm also so much on the receiving end when such type of questions come to the ministry and also survey department. I think, Chair, that's what I can submit for now. Maybe I wait and see of any question or reactions. Thank you so much.
Thank you very much, Mr. Ndu, for addressing those questions, and fully understand some of the issues have gone way beyond the memorandum, but we can always organize another session where we to give time for those ones to be looked at and feedback obtained. Thank you very much. I understand you are away on a training. We really appreciate that you've managed to slot some time to also assist our members on this very important subject. So we also have Mr. Tom Abuta from the Ministry of Lands. Tom, can you hear us? Hello, Tom. Okay, we'll just check. Perhaps it's having a challenge on his end. So with that, we'll move to Mr. David Nyandoro, who will also just give us a brief highlight on his perspective on the memorandum, so that we fully have a good view. We've had the perspective of the practitioners, both who are this discussion and those who are seeing the memorandum the first time. Also good to hear his perspective of the memorandum, and then can address some of the questions that have been raised. But then the key aim for this part is really to hear the ministry's perspective on the memorandum, then address some of those questions. Then we open the plenary for all members to share their feedback. So, Mr. Nyandu, please proceed.
Thank you, Mr. Libin, and members who are joining us on this link. I want to start by saying I think the first presenters have really highlighted the issues that were up for discussion. We want to understand that the background against all this issue, there has been a confusion that it is digitization, but this has nothing to do with the digitization. The essence here is already as one of our presenters I highlighted, Linda, that when you look at this, we have two sections of the law. That is section 54.5 of the Land Registration Act. And we also have section 13 of the SPA. If you look at the section of 54.5, long-term leases. And when you think about it's a network issue, so I was saying that you also realized then the 2 years now, there was an issue that came after the lapse of that time. We were not able to progress, even where we saw there were issues. You want to, somebody really has a problem, and we have so many people who have titles in name of long-term leases. So in essence, there was really hard time on how to handle this, owing that the law had already lapsed by December 2022. This is what actually made the LSK, the Institution of Surveyors of Kenya, the Bankers Association, and said, okay, the business is starting out, we have a business continuity, as people come to understand the changes and also be able to undertake the exercise of georeferencing. in our discussions, really, both all the parties were presented. That is the bankers, the lawyers, and the surveyors. And in most of the issues that raised, I may not want to dwell because I want to believe in your various organizations, at least the information we were discussing, you have already been highlighted from the organization itself, because the document, the memorandum that was signed, binds all the parties to the document. That's the memorandum. Let me say this, that there were options that we were looking at, and I think this is where the issue came, why 6 months, that we had options that we were to choose from. And actually the option that we had was one, whether to go and have amended the law, and in so amending the law, increase the term from the initial 2 years to another further term, 2 years maybe. But we noticed that by the time you make and amend a law, you go through the org of going through the stakeholder, going to parliament, we realized it would take more than a year down the line. So we realized still business could be adding. And for that purpose, we said, okay, we need to look at what is doable for both of us, and how do we make sure that whatever we are doing, then we have to make sure that it is also going to meet the test of the law when it comes to regularization. And actually, that's where you have seen the undertaking part of it, because the essence here was, we want to be sure that, one, the units we are talking about, you are transferring or you are registering exist. As my colleague Ndung has already said, when our team of surveyors went around, more than 20 properties, they found there was nothing on the ground. But already we had registered long-term leases. Bank have taken securities on those leases, but on the ground you go, there is nothing. In 5 of the properties, we found they found mabati houses. Nothing was on the ground apart from the mabati. So you could not see the apartments that were being, where we had registered the long-term leases. There are some areas also where they found only an excavation, and there was no sign whether there is any development going on. So these many challenges, and I think as one of the presenters asked, you thought the government was to put up the expenditure for that. These were some of the challenges that came across when that team went around, that how can it means to give an expenditure, particularly where there isn't not even a structure on the ground. Having all this in mind, then the issue we looked at were, how do we, without necessarily depending the law, how do we make sure that the business is not hurting and the owners are not prejudiced unnecessarily? So we thought the wise way is where we had to look at these long-term leases from 3 perspectives. In the name of new development, means those are where we have not registered even a single lease in our record. That was taken to mean new development, and that's what my sister Irene has already said. Number 2, where you had developed the property, registered 20, some leases, or as an example, you have 50 and you have registered 20, or you have registered 5, that was partially registered. And then we had this case where you have already registered all the leases, and actually you have even gone as far as doing the reversionary interest. So the issue here was, how do we handle this? And then it was easier for us to deal with where is new development, because we said here we follow the law to the letter, so that the owners who are doing this, they must know that the developer is doing this, then he requires to have the georeferencing in mind and those ones we did not provide the exemption. That's why you don't see them as part of what we are discussing. What we are expecting from the practitioners, we are not going to expect that there will be applications for people coming, or let me say Ranet friends coming and saying, you know what, you gave a moratorium, and because of that moratorium, we are coming with this. Strictly, we are saying for new development, please, to theory referencing, comply with section 54.5 of the Land Registration Act to the letter. Now, on the other area is where we are saying, okay, we have this partially. In the partially, what we are saying is that here is where we need an undertaking. And the issue one why we need the undertaking is what we alluded to in Ndungu, that we need to be sure that there are developments on the ground. Because if there are no development on the ground, then even if the developer did an undertaking, we have also put a capping that the registered surveyor, who is a practitioner, a registered surveyor or a licensed surveyor in this manner, will have to do a letter confirming to that effect. We have developed a template to that, which will be filled, because this surveyor will be held to account, and by the time this surveyor is going to append his pen and ink on that paper, we believe already he has secured and has undertaken to undertake the exercise from start to finish. We actually said with this, we are able to start on. We had several issues again around this, which I might not go into in-depth to allude to all of them. But the issue we said is that that letter from the surveyor is enough, and right where we could have said, let the registered owner in form of undertaking provide us that he has already had the plan or not approved. So we have had that, so that we are very sure that even if these transactions go on, then we are going to have the property referenced. I think there is a silent feature on this part of the document that has not been put to right, and I want to put it into perspective, and I think that's what Tom could have talked about, was among those who drafted this memorandum, that we are capping that at least one unit, which we call the Rust unit, for partially developed, will not be finalized until the sectional plan is submitted. What we were trying to cap here is that, so that we have that capping, that before the developer goes away and leaves the property owners struggling, we want to be able to bind the developer to undertake the exercise of geo-referencing. That is a silent feature, and I think your colleagues who are in that team can allude to that as one of the takeaways that we said we need to bind, so that he can be able to assist. Again, in terms of then those which we are saying where we have already registered, we have these all of them gone. I think the purpose of you call it REN, some we call it a restriction, some we call it we charge. The issue here is, at the time the application is made, remember, these are where people bought properties, everybody is living in his property or went their own way. So it's not easier for this person who is doing a charge or a transfer to get all these people come together and actually to agree in doing geo-referencing. Number two, we also looked and we realized it is not easy to give one person a pardon. For example, you have a development of 200 units, and then you say this person who is charging the property, that you now take over the entire project and pay, the cost will be too high. So for that purpose, we came into an agreement and understanding that in this case, this is where even asking this client to get a private surveyor And I think the issue here was raised again, a question that whether ministry would have that capacity to carry all this work. And why we settled that the government is because private surveyors cannot come and put a lien. Them they want to see given their money is more or less the same like asking advocates that you do this and we put a lien on your behalf and you are not paid. I think for practitioners, this is a more of a private business. They would want to see that contract. First of all, conditions profiled as they enter into it. So we said the best way for this one client, again, we also realize that he cannot georeference his unit alone because georeferencing will encompass the entire property. Then the director of survey would give each georeferenced unique number, which we call it a nomenclature, for each apartment or each portion unit. So all of these put in mind, we say, okay, the best way that when this kind of application comes, then the registrar, through the office of the chief land registrar, notifies the director of survey that we have received this application in respect of this apartment situated on this property. So ideally, the chief registrar will be telling the director of survey that proceed, have these properties georeferenced, then at cost of and then give the costing. Then the client, the owners, will repair that cost. How this will be done is that the cost that is given will be spread among the unit owners. So what will be the cost per unit? That cost per unit is what will go, and actually the lien, it should not be seen that it will be placed on the matter title alone. Because if you place on the matter title, people coming to transact are not coming to transact on the matter title. They already have long-term lease titles. So in this case, will it be placed on each unit or each sublease, such that each owner coming, even if he was to take his sweet time, he would actually be able to know that already I have a fee. If I want to make any transaction, then I have to pay this fee first before I can proceed and do any other. For me, it more or less gives now the responsibility of assisting this one individual owner and spreading that amount or cost to all the unit owners in this case, because you understand that even under the Section of Properties Act, there are circumstances where you might find that the owner is not cooperative, and the law looked at that and said, then under the circumstance, even the unit owners can apply actually for conversion and at the same time for georeferencing. So that is already provided for. So there is no, can I say, gap in the law as far as that is concerned. Having said that, I wish to be able, because this document, I would wish that you would be able to have time, you go through if you didn't have, because we want to believe that you were involved by your various organizations. But other than that, maybe if I look at a few, I may note there are issues I may not want that were raised in the questions that go beyond the memorandum. My understanding was when I was requested or invited to this forum, it was to discuss more the issues relating to the memorandum, not outside the memorandum. So I may not go in to discuss specifically issues or parcels that have not been converted because they fall in JKI, they fall in Karura Forest, because I will be going beyond the mandate of the memorandum. So in terms of the first question that was asked was, so are we saying there would be sectional titles and then there would be long-term leases? I think various schools of thought have various ways of looking at this issue. But I think I'll leave to you, the practitioners, to look at it from that, because for us, all we are saying is that fulfill the requirements of section 54(5), and then we have no problem. We'll proceed. The rest will proceed. As is fulfill the requirements. Once those requirements are fulfilled, I'm not a surveyor by profession to say what kind of documents during the georeferencing will come out, and if it is a sectional plan, does it mean then we go sectional? I think they will be able to look at that. But what we are saying, all long-term leases should be georeferenced. Again, the issue of reversional interest are issues I will put in the same category. Because ideally, here is where we need even, again, not us as the ministry, but even you, the practitioners, you need to be able to talk to your clients so that you understand what are their needs. The intention to convert, the intention to sell. You look at that. If this person, the intention was to buy, is he intending to buy so that still it does not retain reversionary? Because the essence here is when you don't retain reversionary interest, then, or you retain reversionary interest, it means the owner of this long-term lease, whenever he's making an application, then he has to come to the developer to get consent. And I think for me, this is not an area I want to be able to go into discuss, but I think it's an area you as practitioners need to explain to your clients so that the time they are making a decision, they don't come back to the ministry and say, why did you give us this one while our neighbors in the next are having this kind of arrangement? Why is it? And again, we need to look at also the spirit in the law, particularly the Section of Properties Act. Why did we have to come up with the Section of Properties Act? Why did the previous Section of Properties Act, why did it not succeed? Why did we have again, why could we not do away with it all together? I think this, if you put them all together, will be able to, for you to advise the clients, if they make a decision, yes, me, I don't want to retain, or I want to retain, then it will be able to understand, but not where one party thinks the other way, but after the transaction done, he realizes it is the opposite of what they intended to have. In terms of first developments, I think this is much to do with the Section of Properties Act. There are, and I think Tom will discuss about this, there are already amendments we had already proposed, which were underway, that the section of properties, there are things we felt required to be made. Particularly, you might find a developer who doesn't have enough muscle to do the entire project at the same time. So they want to first of all, develop a section, sell, get some finances, then continue to develop another phase, then sell, then again develop another phase. But what is critical is that in all this development, you must have a master plan. When this law is finally amended, we expect that there will be not one sectional plan, not two, but depending on how many phases you are doing your project, but all this will be anchored on the master plan. The reason is why a master plan. We do not want to get to a point the people who come to purchase this property, usually they are told here we have amenities. There is a playground, there is a swimming pool, these common, what we call common areas. But in most cases, the issues that we are having cases now, particularly these areas of South C, part of South B, are where people are coming and saying, you know what, this place was placed for us as a playing ground, but the developer has come and excavated and is now doing another building. So in this case, we want to be able to have that master plan so that it does not become an abuse again of us abusing that, and then the people who buy then realizes this property they bought is not meeting what they intended or when they were given the initial picture of what they were entering into. I think that will answer that, and that also comes in to talk about that issue, and you realize that issue where he talked of exemption. It is because the law clearly, when you go to the regulation and exemption, you don't see it in the law properly. Then in terms of, again, development of strategic importance, sometimes in this case, particularly, I would talk of EPZs, where government still wants to retain the property for specific management because they want to see that what they intended that place to be used for is not changed. And for this, that's where those kind of developments will actually have an exemption, and the one will have to qualify within those of strategic importance before we can be able to give any of this, and there would be a lot of things that will go into this. We have also some of these. There would be some cases where you see the government want to bring in people buy, but there is again another developer contract. There are so many steps going into it. I would leave at that. In terms of, let me see whether there is anything I've left out. Properties outside Nairobi, I think Indumu responded on this clearly, that even without the section of properties, most of the properties outside Nairobi were RRA, properties registered under the Registered Land Act then. And actually, then the Land Registration Act required that before you do sectional properties, you were supposed to convert to be able to proceed with sectional. We expect that there is nothing new coming into it. They will go through the same memorandum and must meet all the requirements as agreed, because we do not see any variance. I think again, Irene talked of the issue, and I don't want to repeat it, about when will we do manual registration. We already have developed for long-term leases, but this again where we have converted, I want to be very clear. We have converted, so we will be able, that is already there, we'll be able to maybe have a session through Living and the team, and then we will be able to see how we can take the practitioners, particularly the users. We will do maybe, I don't know whether the way you will decide it, maybe it will be another session of training, maybe can be organized even in the form of CBD. Then we have many lawyers coming on board so that we are able to have many trained on this, particularly on how to do it through our Sasa platform. However, where the property, again, there is an issue we are still insisting on, where the property is converted, is not converted. As a practitioner, I think you should take keen interest, understand why is this property not converted. There are so many things. You cannot say just one thing made this property not to be converted. There are so many things when it came to conversion. Actually, some properties we say they are not converted. When you go to survey, you realize they were subdivided and the subdivisions were converted. But the owner never came to register the subdivisions and went on to transact and even sold. Because when you are selling, you don't go back to the director of survey and there is no document this side, then we continued like that. We have had a number of those cases where the owner comes and says, have not subdivided. Then when you check in survey, you realize the person who sold to this current owner is the one who had actually started the subdivision. So some of these things, we cannot say it's one specific thing that this is why. There are so many, and it's very important for the practitioners. If it is not, before you even, you need to find out why was it not converted. We know we have several properties that actually fall on public utilities. We have properties that follow within the Mombasa Road, for example, the expressway, particularly the roundabout there. So we have a number of these issues, but as to how and when, I think this is an issue for another forum that I cannot be able to pick, because the question that was asked is to give people, how can you get this information? And I think it would be for a different forum, not for this forum. You asked an issue, who shall approve when you make this application, how will they be made? Let me say this from the onset, that for purposes of control, we had said they will be submitted to the office of the Chief Land Registrar. There will be officers who will be given to do that work, not necessarily the Chief Land Registrar, who will be able to. But what I advise for you to make it easier for those officers, as you make your application, please attach the copy of the title. Attach the copy of the title, because it is the copy of the title that will tell us exactly whether this is a new project, this is a project that is underway, or this is a project that has been finalized. That way it will be able to assist us. But I know for those who have already registered long-term leases, who could have the logistic of having a problem of attaching long-term leases, our officers shall endeavor to try to confirm from the system whether we have any already registered, or locate the file for purposes of confirmation. So where you have not attached copy of the title, you realize the officers then will be forced to get to GDC to retrieve the fiscal file. So in terms of how long this then will take, I may not be able exactly at this moment to say, because we have not done any test to see, then to come up with that. So I think in terms of approving, that's okay. In terms of the 6 months, we have said again, remember we are not amending the law. This is an interim, and an interim cannot be a kind of a forever thing. But I also remember the team that was working on this, because we had surveyors, we had everybody, and we asked ourselves, how long does it take to get a section of planning all the way to the director of survey approved? Previously, we have been having the issue that it takes forever. But when we went to those people who have done it practically, we realized it's not a big deal. 1 month, 2 months, it is done. So that's how the issue of the 6 months came about, which again caters that we also do not want to open an open-ended kind of date without having to come to an end. I think again, Ndungu responded over a sole member. Sole member cannot have a conversion on his own, but a conversion will require that the entire project actually picture referenced. I remember the question that was asked is as to whether conversion and georeferencing, what point do they meet? I want to be able to say this. Properties have been converted in Nairobi. And for the properties that are already converted, we will not be able to register a new transaction in the name of long-term leases unless the title is converted. And then we proceed. That's where we said we have provided a platform. We proceed to register the long-term leases under the converted title. Remember, the moment we converted, the law says any subsequent transaction will be done on the converted title. I think it's important we make also this clear, so that we do not have a case where practitioners are coming and saying, but we agreed you need to give us time, we finish and then you convert. No, conversion is a standalone. It requires, whether you have a transaction or not, you are required to convert. It is more or less the same. If you have a church, you come, we tell you it is converted, you convert in the same way. I think then this makes very, very clear that, and I think the memorandum is there if there is any issues. I think the team who you had from LSK are there to maybe make some clarities, and us who our offices are also open. But I want to say that this was a kind of negotiated understanding on how do we assist to unlock business continuity. That is the bottom line. In ideal situation,
All right. Thank you. Thank you very much, Mr. Nyandoro, for that input. And so, members, we had planned to be done by 4:30, but we are just 15 minutes to that. And Mr. Abuta is yet to speak. So I'd request that for those who have very burning issues that have not been addressed today, you just raise up your hand, then we give an opportunity for quick questions. Then Mr. Abuta will address the questions, and if there's any which need someone else to address, we'll give them a short while to address, so that we also don't take the entire afternoon, because we understand the people we have in the call, and you on your end, you also have other items you need to deal with. But because of the depth of the issues that are coming up, I think from LSK Nairobi, we'll work on seeing how we can make this an ongoing conversation, so that we can continue ticking off the issues that have been solved and addressing the ones that keep on coming up. So as we are raising hands, let me test and hear if Mr. Abuta, are you able to speak? So that let's confirm you're able to speak. But in the meantime, members who have burning questions, Tom, you can hear us?
Ripin.
Yes.
I can hear you very well.
Fantastic. So just hold on a bit. Let's see if anyone has a burning question. Members,
Very well.
If you have any burning questions, please raise your hand. Then we'll take a few questions, then close this session. But because of the interest that has risen up, we've taken note of the questions on the Q&A section and in the comment section. We'll definitely have all those addressed, and we'll also organize another session, so that this then becomes just the introductory aspect, but then we proceed. So I can see Maureen's hand up. Who else, members? Any questions, please just raise your hand right now, so that we see how to deal with this part, so that once we close, then we would already have covered everyone. There's a member who had reached out earlier. I don't know if they are still on the call. This is Mr. Tobias Ongalo. I don't know if you're also on the call. Okay, I think then those are the two burning questions that we have. We'll have Maureen. Leonora, please enable Maureen to be able to unmute. And Mr. Tobias Ongalo will take those two questions. Then we'll have Mr. Abuta also give us his remarks. Then we close this session for now, but we'll definitely have another session where we'll expand the platform. There was a much more huge interest. Members wanted to join, but the platform could not accommodate, and also give the team also time to look at the questions that have come in, so that we can have other more comprehensive feedback. So, Maureen, if you've been enabled to speak, you may proceed.
All right, thank you, Ribin. Just confirm you can hear me.
Yeah, I can hear you.
All right, thank you very much. I will just start by thanking everyone in the committee who just came up with a memo. I think there is progress in the right direction. And, Mr. Nyandoro for, taking the time to just address some of the questions. Adnan, also you came up with a really comprehensive and great list of questions. So I'll really not go into that. And I will just be speaking to one issue which he highlighted, but just maybe to, speak to that further on the issue of the lien that is being placed on the leases. My question is, one, does the director of surveys then, in coming up with a cost, appoint the surveyor who would do that you're referencing on behalf of that particular development? And how he would go about appointing those particular surveyors who do that, because this seems to be divorced from the developer, because it's being done independently. And the second question would be, since the lien is placed in terms of a cost that ought to be paid by each leasee, then where is that cost paid? Is it paid to an account that will be set up? So my question, where would that cost be paid? And my third will not be a question, be a comment. Some of the questions, because of when the memorandum was released to everyone, and and when this meeting is being done, some of the questions, I would suggest that the questions are either taken away to the extent they're not answered in this meeting, and perhaps the committee can deliberate with the ministry further, because I think some of the questions that came from Adnan's list, if they were answered, we would have a very clear direction. That is it for me. Thank you.
All right. Thank you, Maureen. Mr. Tobias, are you online? Okay. I think we give Mr. Abuta the platform to address anything which has not been addressed and give us his remarks. Then for today, we request members, we allow us to close the session this time so that we don't keep people here for long, but then we'll make it an ongoing discussion so that then we can be resolving the issues as they go. So Mr. Abuta.
Thank you, Ribin, and everyone on call. Yes, I was privy to this memo, which has been given a lot of meaning by the people who have spoken before me. And I think now it's much clearer to everyone of us of what it means. Let me speak very quickly to the issue that are by Maureen. That work which they were not going to be sure to get paid. And so that's why we pushed it to the director of survey to handle on such cases where we have all the long-term leases registered in a given property. And so for him, once the registrar has received an application, any kind of application, then it means after the registrar is satisfied that that transaction can be carried on, then one of the things that the registrar does is to pass that application to the director of survey, simply instructing him to carry out the survey, the georeferencing. And so after he does so, after determining the cost, then I think it behoves on the registrar to have that cost split. That is, once a sectional plan is done, registered, it leads to opening of various registers for each unit. So every unit will be assigned a cost, and that is a lien on that very unit. And so when that person comes to transact, then he finds he has to charge that lien before he is allowed to continue transacting on that property. So the lien does not necessarily apply on the whole property, but it is on the split portions of the property. That is in accordance to the sectional plan. And so the question as to where the cost gets paid, I think that is not an issue we dealt in detail, but I want to suppose that this is a case where you require the person who's coming to transact to have proof that he has finished with the surveyor. No, not really with the surveyor. He has yeah, that's a little bit. I'm taken aback because this is the director of survey who has conducted the survey. Then it means there has to be a mechanism on where such monies will be paid into. Because I'm confusing this issue with an occurrence that happened later when we met with the private surveyors when they came for the signing of the agreement. I think they were taken aback and thought they were going to lose. So they started saying that, there's no need for director of survey to do this. We can do it as private surveyors. We are willing to do this so that the cost can be paid to us. So that's an issue that will be explored, where the cost will be paid to. So I hear you. That is really a concern. Ribin, I can say that most of the issues that have been raised here have been addressed so much in detail. Let me look at some of those issues that have not been. Someone is asking whether long-term and sectional titles, can we proceed with both forms? How is it? Does it mean that one they will exist alongside each other? I think that is a yes. Currently, we can't say that the long-term leases that I provided under Section 54(5) have been repealed in any way. Well, that happens. What the Sectional Properties Act speaks to are issues where you have irregular long-term leases out there. And so for them, they need to conform with the Land Registration Act and even the Sectional Properties Act. So where it will be necessary, yes, you will have both forms, that is the long-term leases. That method of owning property has not been repealed. And so we shall, in cases where it requires, we shall have long-term leases. There's a question that was someone, I think it's Adnan, asked about the exceptions that I provided in the regulations. Though I didn't hear very well that question under the exceptions provided. Probably you can clarify on that issue later. Properties outside Nairobi, that has been answered. On whether the director of survey will proceed to geo-referencing the properties as the registrar does the registration, I think that one has been answered. Are people going to be forced to conform to sectional property? I do not think that is the case. No one is being forced to conform to the sectional properties, but what we are saying is that where the people, the list of those who have been listed in the regulations to commence that conversion process, where they're willing to do so, I think nothing can stop them from going the sectional property way. And so there is nothing in the law that says that people are being forced to conform to sectional properties, but where you have such owners as spelled out in Regulation 18, I think 19, 20 up to 22, because it talks about conversion, where you have them willing and the issue of the reversionary interest spelled out in the agreements, then they can convert to sectional properties. I think, Ribin, I can stop there unless there is an issue that I've not addressed.
No, thank you. Thank you very much, Mr. Buta. You've covered that. So, ladies and gentlemen, from the questions and also from the respective chat groups, there are a lot of issues that are coming up. So, but we have to close this meeting at this time. But just send us the questions. We'll take them down, and we'll see how to make this a continuous discussion so that we can keep on unloading a number of issues that are coming up. So just to close, allow us to give the panelists a minute each to just make their closing remark and anything they think it's important that needs to be shared before we close. So perhaps we start with Irene, then go to Adnan, Belinda, Ndungu, if you're still on the call. Yeah, I can see still there. Thank you very much, Ndungu. Then Abuta, then we'll finish with Nyandoro. So in that order, a minute each. Just give your closing remarks and anything that you think it's important for members to take away from this session as we plan for the next session to ensure it's a continuous discussion. Irene?
Good afternoon, members. Thank you. I think I've tried to respond to some of the questions on the chat that members have brought on board. For me, I think all the highlights have been indicated, and it's work in progress. Any challenges, I guess, that we may have, let's channel them, and let's have an objective mindset with this milestone that we have had with respect to unlocking the issue of registration of long-term leases. I think just the only part in short I would like to indicate, because I find that there seems to be a bit of confusion with respect to long-term leases and sectional titles. Please, members, note this is not limited to Nairobi. The issue of compliance is across the country with respect to what is happening. So again, if it doesn't matter whether you are in Nairobi or in Machakos or Kiambu, the issue of compliance with long-term leases and the SPA is across the country. It's not limited to Nairobi only. Thank you.
Thank you, Irene. Belinda?
Thank you, Ribin, and good afternoon, members again. I think for me, just to appreciate LSK Nairobi Branch for putting this together, and also to echo what Irene said, any issues that we may come about as we are implementing. I've seen a few questions around transfers by chargee and where banks are exercising their rights. All those issues as they emerge, I can confirm we had a very receptive CS and PS in the discussions and in hearing out the recommendations, and also Mr. Nyandoro and Mr. Abuta. So we shall continue engaging with them on any issues that are not able to be reconciled or agreed upon by this committee. I'm sure we'll be able to escalate. Also through Helen and Eric Theory, through the PS and the CS, and to see if there's any other way to work around this. But for now, there's an avenue for some of those stuck transactions. Let's engage. We're about two weeks in. Let's engage and let's see what challenges emanate. And then if we need to reconvene to have a further memo or further discussions, then I'm sure the office holders will be more than happy to accommodate, and we are available to continue engaging. Asanteni sana, and good afternoon.
Thank you, Belinda. Adnan?
Thanks, Ribin. I'd just like to thank the LSK Nairobi branch, Mr. Nyandoro, Mr. Buta, Mr. Ndungu for having made time. We don't take it for granted. If I thought my desk looked super busy. I think people should go and see Mr. Nyandoro's desk to understand how much work he does. So we don't take it for granted. The only parting shot I think we need to do, Chair and Ribin, is perhaps we take stock of the questions or issues that I had shared earlier and members have posted on the Q&A, and together with the ministry perhaps come up with responses, and I guess perhaps prepare an FAQ list which we can carry on preparing. But I think at least with the initial questions and responses, if we can have like some sort of timeline, because like I said, unfortunately, clients are a bit frustrated with us not having answers. So the sooner we can have something in which is documented, which would help us explain some of these points to the clients, the better. So, if we can have an FAQ with responses supporting the memo, that would be helpful. Thank you, everyone.
Thank you, Adnan. Definitely, we've taken note of all the questions today, and we'll follow up on that. And as we've said, we'll find a way to make this an ongoing forum so that the issues can be resolved as they progress. So, Mr. Ndunu. He must have dropped off. He was attending something else, and as I thanked him earlier for being gracious enough to make time to also contribute to this. So we'll have Mr. Abuta, then close with Mr. Nyandoro. Mr. Abuta.
Ribin, mine is to thank everyone because you realize that there are many issues, and even then many will continue emerging. I think the most important thing is to keep the communication channel open, so that when these issues arise, we will always be ready to tackle them. I think the ministry is more than willing to partner with few people to see that things move. Otherwise, I thank you so much.
Thank you. Before I give the opportunity to Mr. Nyandoro to close, allow me to have also a council member in Nairobi Branch. It's called Teresia Nicholas, to just give a 1-minute remark. Then I will give Mr. Nyandoro to close. Teresia.
Very much, Ribin. The session was quite stimulative and learned a lot. And as you have mentioned to our members, all those questions that you have all asked, you're going to be able to respond. So I cannot wait to see the next handover after this. So yeah, thank you very much, Ribin, for conducting this together with all the panelists. And above all, I want to thank our members who created and made time to be here. Thank you, and I hope to see all of you in the front.
Thank you very much. Now we'll hand over to Mr. Nyandoro to give his parting shot. Then we'll close the meeting. We'll communicate to you members the time and meeting for the next session, and also we'll have a follow-up on the questions that have been pending, and also ensure we get feedback on that. Mr. Nyandoro.
Thank you, Ribin, and all members. I want to thank you for creating time for us to handle an issue that is actually very important to, particularly to owners of sectional units where we have had a business stall, and I think we have clarity. And as I would say, Brenda said, we say that still if there are any issues, we will be ready and willing to engage. Let me say again, or even take this time to inform the members that you remember at the time we were caught up with this law, there are practitioners who actually met their applications to my office, and we were unable to approve. And I will urge these members now to take advantage of this, check some of those documents. I know some of them were not picked from my office, so that they can get whatever documents we have requested them to provide to enable us to proceed, I think this will be an issue that we need to, from my office, we want to commit to give priority, owing that these applications were met in much earlier. In terms of probably an issue I think my colleague Tom alluded to, as to how the payment will be made, I think it's a very important issue. While I want to agree with my brother Tom that we actually never discussed about that, but I want to look at it from the subdivision point of view. Usually when you are doing subdivisions, you go to the Director of Survey, there are payments that are made through the Office of the Director of Survey. And these payments that are made are government payments. So the surveyors who will be doing this work, we are not likely to anticipate the Director of Survey to appoint private surveyors, because we had the surveyors on board, whether they were willing to undertake this exercise and wait for this for the owners who will come even after 10 years to make that payment. And we realized the condition was that then the government to pay them and the government go to get the owners reimburse them the money. So I think it's an issue for the Director of Survey, and we hope this will be an issue that the government will directly undertake. So the payment will be made through the Office of the Director of Survey as government payment, which of course you will be given a notification, and again on how those now restrictions or called encumbrance will be lifted to allow the owners to be able to continue. With this, I want to once again to thank the Law Society of Kenya, the Kenya Bank Association, the Institution of Surveyors of Kenya, particularly for taking the initiative to engage the ministry in actually saying put the law and personal interests apart, and we looked at the common person here, who is the unit owner, who owns that long-term lease. And I think going forward, this is showing us that it's not always we should be fighting on how certain things should be done or what does the law say, but where we look at what is it at stake. Just as the doctors too, if a person is taken there was an accident, they will not say that bring his people to sign and it's on emergency, they will operate. And then later on ask where the owners to come and sign. And I think this one where we have seen, actually we can work closely, because LSK, surveyors, bankers, you are our major clients, and we don't take that one for granted. My office will always be open once again. If we have any issues that we need to interact, whether you put them through your branch, through the LSK umbrella body, or at personal level, we will be ready and willing to offer any necessary advice. But I also want to say that I want to thank particularly the teams that came to this work when we were doing engagements, because the engagements were not easier, but every time we had an hurdle, we were finding a solution. And I appreciate all those members who attended, because we were solution focused. Thank you very much, and God bless you all.
All right. Thank you, the team from the ministry. Thank you, members. We know each and every person on this call has a very busy schedule, but we appreciate for taking time on this. As I said, we've taken note of all the questions. We'll follow up on responses, but more importantly, we'll communicate to each and every one of you in the next session so that we make this a continuous discussion. Thank you very much and have a good afternoon. Asante, you may leave at your own pleasure now.
Thank you, Ribin.